Greetings and salutations. Today we're talking to David Myrland, the man, the myth, the legend. He's been doing this law stuff for 30 years, and you can tell he has a sharp mind and can recall wording and numbers and all of that from all of his cases. He remembers where everything is on his website, and he will be telling you that and explaining to you along the way. So get your pen and paper ready to write and be able to find this information. A lot of it is contained on his USB drive that he sells for $200, and he sent one to me, and it is a encyclopedia of legal knowledge on a lot of different topics, from travel to income tax. He's probably got some property taxes in there. He spoke of one instance that he did with property taxes, but I think he might defer to Steve Emerson on the property tax issue. But everything else, he is the go-to guy. He thinks outside the box. He's heavily involved in criminal complaints to force these criminals to do their job and to lay off you. So I can't stress enough to get in the Telegram group so we can coordinate any seminars that he talks about he wants to do for us and whatnot. If you are interested in a seminar, please leave it in the description below. I'm going to leave some websites that he's referenced in the description, but also leave a comment and see what area you're interested in and what kind of seminar. I think he said if we all did $25 and got 100 people together, he would do a 2.5, 3-hour seminar for us on a specific topic. So I'm thinking travel is probably a really good one for this group, but maybe I want to do income tax or something like that. So just leave it in the comment section and we'll get to it. Without any further ado, let's get to the conversation with David Myrland. I know you'll like it as much as I did. Here we go. Welcome, David. Thank you for being here today.
My pleasure, of course.
Absolutely. First off, can you just tell us how to find you, and then we'll get into all the subject matter.
Yeah, the first thing I have to tell everybody is get ready to write. Have your pen and paper at the ready. I'll read you web addresses. This is not a lesson. This is a sprint through what I've done since 2014 and the contents of the flash drive where I make all of it available to you. It's worth 20 times the cost. So get ready to write. What you need to know is my name is David Myrland. Welcome to the Gary Brown Show, is it?
The Legal Beagle Podcast.
The Legal Beagle, great. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis, believe it. It's May 13th of 2024. Now, the course matter, the curriculum, the materials I sell are all on one flash drive at present, and it's available at bgbgbg.us. bgbgbg.us, and you'll see some links there. You'll see a link to my YouTube channel. My YouTube channel is called Take from Caesar. It's a free library of teachings I think I've got 55 or 56 tutorials there now. You want to watch the first 15 tutorials. They're the ones with a lesson plan in it. And throughout the rest of my videos, from those first 15 videos I did, most of the content for the remaining videos stems from experiences where the strategies I discuss in the first videos are brought to bear. And I mean against government misconduct. I've really worked almost exclusively in my 33 years as an advocate for innocent people. When I can prove somebody's innocent, I can make real problems for the prosecutor and for the judge. So bgbgbg.us, links to my YouTube channel called Take from Caesar. Takefromcaesar.us is another website. I built it after October of 17 because I intended it to be an addition to wevgov.com. WeVGov, like Roe v. Wade, wevgov.com is an expose on my tax findings and my approach to the motor vehicle code. You can deem my specialty to be IRS. That stands for Internal Revenue Service. It stands for illegal revenue streams, and it stands for ignorance reaps slavery. There are specialties that I've gathered, and my focus has always been on wrongful taking of property, privacy, or liberty. So I found instances where the government's taken dollars right out of my pocket, and I look at the law and I go, excuse me, but the law doesn't reach you to give you this authority over me. My approach to the tax code, and this is my 1994 treatise. It's in like another century, called Codebreaker. In 1988, the IRS ticked me off. 5.5 years later, I emerged from my research with my own list of conclusions where I felt there were arguments to be made against the IRS's standard operating procedure. I briefed those arguments, and a bunch of people took them all to tax court. I took 5 of those clients myself all the way to the Supreme Court by October of 98, learning as I went. I'm self-taught, and that was my first project in litigation, was 5 trips to the Supreme Court in the hardest law on the planet, with my own treatise and my own conclusions about what the IRS and the tax code really mean, whether or not they're the same thing. I've discovered they are not. And since the IRS owns every judge, I knew by the end of 1996 that federal law was nowhere. So I gravitated out of federal law toward state law, the motor vehicle code, of course, and traffic court, and teamed up with Kurt Riggin, not as an associate, but I could get him on the phone anytime I wanted. He knows 10 times more about the law than I do. My tax specialty is mine alone, but you get outside the tax code into broader areas of law and approach. Kurt Riggin is a genius. On my YouTube channel, you'll see 2 interviews with Kurt Riggin. He's terminally ill from several things, so he could leave any minute. He's outlived his many doctors' prognosis by 8 or 9 years now. Mesothelioma, a couple other forms of cancer, fractured liver from a beating that the cops gave him in February of 2002. He's got injuries to his liver where they kicked him in the abdomen. And his doctors said they have only heard of something like 1,796 instances where someone received that type of injury to their liver. And Kurt's the only one out of all of them that survived it. So his liver's been functioning 20% since February 2nd, because nobody can figure out which direction the blood's supposed to go. The fractures are so bad. Anyway, wevgov.com is first, and it outlines my heaviest lifting tax arguments. On Take from Caesar on YouTube, you'll find a video about the motor vehicle code, a video tutorial about Section 83, a video about the fact citizens of the U.S. are only named in regulation, and they're showcased as my heaviest lifting argument for IRS, illegal revenue streams. So you start by studying everything on wevgov.com. Then you go to my YouTube channel and take some of the earliest videos. The video on Section 83 is 2.5 hours long. I'm the only one that's ever even written about Section 83. I completed a manual about Section 83.
And just to be clear, Section 83 is pretty much where all the tax honesty movement people get it wrong. Is that right?
They've never heard of it. They've ignored it. So in 1994, spring, 30 years ago today, I was touting the completion of my manual on Section 83. I added to it in 2014, I think, an epilogue. So it's everything anyone's ever written about Section 83. I'm the only one that teaches it. I'm the only one that features it. I'm the only one who knows how to interpret it. When I confront others with it, they just poo poo me. Pete Hendrickson says it's gibberish. Stick with cracking the code. That's his book that lands people in prison. And David Champion has another comment about it, like it's gibberish or whatever. They tout their own teachings when in fact, and they know this, my teachings have been available since 1993. They know this, that the IRS General Counsel, appellate courts, and tax court say Section 83 explains how to tax all compensation, and they ignore it because they can't interpret it. They're boneheads. They put a plaque on the wall, they publish a book, get a bunch of people in prison or in trouble with liens and levies. Great, proud of you. Do you understand the tax code? No. I got a video that I watched a little while ago. Is David Champion's video called "Why Federal Gun Laws Don't Apply Within the 50 States," and in there's a gem. He says, "Yeah, in Chapter 21 of the tax code is FICA, which most Americans mistakenly believe to be part of Social Security." Well, no, it is part of Social Security. I've been teaching it since '92.
Well,
It's social.
before you
No,
go
hang
down
on.
that path, go ahead.
Just a second.
Okay.
FICA, Chapter 21 of the tax code, is Social Security for the employee. It's what's taken out of your paycheck when you work for somebody else as an employee. Chapter 2 is self-employed Social Security. They're both Social Security. One is for self-employed and one is for employees. And he tells you right in his video, it's not part of Social Security. It's a no-brainer. He's wrong, and he's had 30 years to pick up my materials and learn the contrary truths. On weavygov.com, on the federal income taxation page, you'll see this argument described, and you'll see Social Security left out in the cold as a tax that obviously does not apply to citizens of the United States like me. They say, I'm a citizen of the United States. And I say, okay, now let's see what the law says you can do to me. I have a totally different posture to enter tax law analysis than everybody else because, quite frankly, in the tax code, the way it's written, I want to be a citizen of the United States. I got all kinds of protections in there you wouldn't believe. And I'm the only one that teaches them. So my YouTube channel is second, weavygov.com is first. And then you go to takefromcaesar.us, and there's a few things that I've layered on top of weavygov.com because in October of 17, tax court labeled weavygov.com a tax protester website. And as you look at that site, you'll see me to rely on nothing but statute and regulation in a way they can't refute. Get ready to write down another website and then I'll take your question. weavygov.com / capital O small RTH. That's a last name, Robert Orth. weavygov.com / Orth with a capital O. That'll take you to an exchange of briefs between me and the Department of Justice in the Robert Orth appellate case out of tax court, where they've had these arguments since 1993. Hello. And they do this poorly on them in 2017 when I went up against the DOJ on appeal from tax court with my heaviest lifting arguments. You'll get his opening brief, you get the government's reply brief, and then you get his opposition to their reply, all three of them. And then the court's order that says, we're giving the judgment to the government, but what we need is to hear from the appellant, Robert Orth. We need to hear from him why we shouldn't penalize him $4,000 for frivolity. He argued only the law They can't deny a word of it. You got their replies right there. They won't even mention 35 statutes and regulations, but he's wrong. So wrong they don't have to talk about it? I don't think so. It's called law. I did it the hard way. This is law, Your Honor. So he filed a complaint for mail fraud with the FBI against those three judges. One of them was the chief of the Seventh Circuit. And he filed it with the FBI saying mail fraud. They're extorting money from me through the mail. All I did was argue the law. And he sent that back to the Seventh Circuit with a cover letter saying, I don't think there's anything in the world I could say that would keep you from penalizing me for arguing nothing but the law. You run from it, you won't talk about it, you can't interpret it, and you're penalizing me for bothering you with your job. We knew he was going to be punished when he filed in tax court. He reserved his arguments for appeals because tax court will penalize me. So I hereby reserve these arguments for appeal. And he gets on appeal and makes the arguments, and they penalize him. We knew they would. This whole exercise was to prevent an indictment. He wasn't filing, he wasn't paying. And so he was flapping in the breeze. And he did all this to make him appear more like he doesn't believe he has a duty. That's one of the definitions of innocence. I don't believe I have a duty. I'm the one that can prove there's no duty to believe in. The tax code does not impose a tax on the fair market value of your labor, and it does not impose a tax upon the gross income or capital gains of a citizen of the United States. And I've briefed it, been to court and been to court and been to court, been to court exhaustively. You wouldn't believe it. And nowhere is there a record of the Department of Justice getting into these provisions or tax court, or they would have cited those cases in the Robert Orth exchange of briefs as cases that disposed of these arguments. So I can wrap them around a telephone pole with these arguments, and they're the biggest arguments. Do I owe a tax when all I've done is sell my labor? And does the tax, has it been written to apply to the 50 states or citizens of the United States? I brief all of it using just tax provisions, and it screws the government right off the road into a telephone pole every single time, beginning in 1993. That basically makes me the grandfather of what would have been me in the tax movement, but in 93 I got turned off when a whole bunch of people got penalized for frivolous filing. I said, I don't need any of this, and I began to ignore the movement and do my own research. And that's when I started really learning about the tax code. It was about 4 years into my research. I turned off the movement and started at page 1 and researched the tax code myself, and I found some stuff. I gained an understanding of some other stuff. And when you put them all together, you can run right through the tax code and the government falls away, except for corruption. You can't predict corruption, so I'm not going to tell somebody it always works every time. What I specialize in is criminal proceedings and these findings, because a jury can still say not guilty. Whereas if you don't have a jury involved and it's just a tax court judge, you lose every time and they aren't going to talk about it. But if there's a jury involved, that's the conscience of the community. If you're in front of a jury and you can prove, I don't believe I have a duty, they're silent on this. I've sued them and sued them and sued them. And, and even then, there's no guarantee because a judge is involved. Every judge is corrupt, period. Every tax man owns every judge. And I've proven it and proven it and proven it. I got all the briefs in the world. So read the exchange of briefs on weavygov.com/Orth. There's a link to an audio tutorial about that page. There's a link to a YouTube tutorial about that page right at the top of it. And thereafter, gosh, it'd sure be nice to get a bunch of Dave's stuff on flash drive in Microsoft Word. Then you go to bgbgbg.us and you get the flash drive. It's there for $200. There's a link on bgbgbg.us at the top of the page to a YouTube tutorial about the flash drive. It'll take you to Take from Caesar. One of my most recently uploaded videos is about the flash drive and its contents. It's the video table of contents for the flash drive, which is absolutely loaded. The Legal Beagle got his about a week ago.
Yeah, absolutely.
And
And it is packed with a lot of information. It's going to take you a lot of time to even begin to read it all, much less comprehend everything.
right. And what I've done with that particular dilemma is I really favor criminal complaints. So I'm strong on criminal complaints. When I picked up and started dribbling criminal complaints, I finally got some respect. About 2001, a Washington State limited jurisdiction criminal rule. That's for courts that can prosecute up to a gross misdemeanor. Felony goes to county superior court. And there's rule 2.1, citizens' criminal complaints. I said, how about that? So I started looking at the criminal code, looking at the prosecutor's job, how with one page of paper, with one paragraph on it, they can get somebody in jail. While I'm over here, my client's over there with a 15-page memorandum. They don't even talk about the law that's in the memorandum. And this person goes to jail because of one paragraph from a prosecutor. What a bunch of BS. So I started looking at what prosecutors say in their criminal complaints. I write better than any attorney I'm going to go up against unless they're at the Department of Justice. So criminal complaints from me look like justices wrote it. And I got turned on by criminal complaints. New Year's of 06, I filed with 80 members of Congress a criminal complaint of 33 pages, a 58-page memorandum, a 12-page cover letter with a couple of exhibits, some exhibits to the memorandum, all told 180 pages. And I filed it with 3 committees and Ron Paul, every member. It cost me almost $6,000 to mail it to 80 members of Congress and have it distributed, all the postage and the notarization and so forth. And that's Exhibit A. When someone brings my arguments to bear is they tell the court, first, Exhibit A, here's my affidavit where I filed as a similarly situated witness to crime. I joined that complaint that went to 80 members of Congress in 06. What complaint? Exhibit B, 180 pages, my complaint with all of its exhibits. And it's a racketeering complaint. Racketeering, conspiracy against rights, extortion, the crimes that are obviously committed when the IRS demands money I don't owe. So it's a criminal complaint about what they do with a 58-page memorandum containing the arguments, briefing how they're misenforcing the law. And I did a bunch of work under the Administrative Procedures Act, 5 USC 706, since 2014. And poor old Richard Boggs on the East Coast, 2014 and 2015, 2 suits with him as a plaintiff filed into U.S. District Court in South Carolina. I wrote those 2. Then he joined as a similarly situated plaintiff to 2 North Dakota lawsuits I wrote for somebody else, just my findings. And he wrote 5 lawsuits of his own and filed them, didn't even tell me about them, took 3 of them all the way to the Supreme Court. Never got an answer about how he was wrong in his interpretation of the law, which is my set of conclusions. And he was still indicted. And 90 days before trial, his hired attorneys went to sleep and he got screwed out of his trial. None of the findings were brought to bear, despite his history of proving that he doesn't believe he has a duty. So I did my best to get him dismissed after the conviction, which is probably one of the hardest things to do, a tax conviction, to get an acquittal after the guilty verdict, but before the sentencing. It's a Rule 29 motion. And you get all of those arguments in Microsoft Word that I drafted on Richard's behalf when he, in fact, was a co-plaintiff or a lead plaintiff, total of 9 times since 2014. So you get these civil complaints in Microsoft Word, all the briefing of all the arguments I thought should come into play to get a guy off of those charges when I've been an advocate since 1993 on my treatise. So it's a showcase of what I would do to try to get a 29 dismissal. He didn't get it. You can't predict corruption, but I have shut down IRS criminal investigations. I've gotten tax grand juries to say, we're not going to hand down an indictment on this guy. We don't think he's willful for other people. So shutting down criminal charges is where I've chosen to stay, because I can still make a difference. If there's no trial jury, like in a civil case, you lose. Tax cases are worthless. Every judge belongs to the tax man. But in a criminal case, I can still make a difference. And you got all of my best and most recent writings in the APA folder on the flash drive, the Administrative Procedures Act folder. Go to YouTube and take the video table of contents tutorial about the contents of the flash drive. It's worth easily 10 or 20 times the price. I write, very well. And when you write the way I write, you're going to look better than almost any attorney you go up against. Certainly county, maybe even Midwest state attorney general. Okay, yes. You're going to compare to a lot of people that have written a lot and been in litigation a lot.
Yeah, we've seen some real shabby grammar from the lawyers that we've seen in the arena.
And that's nice, that before you file your paperwork and before it goes to court, it's going to be like 2 or 3 weeks because the other party gets to object. And during that time, I want the judge to be thinking, wow, the prosecutor bit off more than they can chew with this guy. This guy can really write. It was nice in one court. The prosecutor wanted time to amend the criminal complaint against me for driving while license suspended or something. And he said, I'd like a week to amend the complaint. I said, objection, that comes right out of the time I need to perform discovery. And the judge lowers his glasses on his nose and looks down at me and says, I don't think it prejudices you one bit, Mr. Merlin. You're obviously no neophyte to the judicial system. Your pleadings are in the top 1 percentile of everything I see in this court. Motion granted. So when you look at my pleadings, understand that's how you're supposed to write. Where when a lawyer or somebody else, especially a clerk of the court, sees and goes, who did this work for you? You're making strides. So you want to look better than the other guy. I was a great community college track and field athlete, and my job is to make the other jumpers look terrible. And I got good at it. Go to a particular meet and beat 6 universities as a community college jumper. So I was heavy into competition, and that spirit comes through to how I handle litigation. And you'll find enormous focus on my part to provide you with densely compact teachings in my writings, to where I'll say one thing, the tax has to be imposed by clear and unequivocal language. And then I'll cite 7 or 8 Supreme Court cases that say the tax has to be imposed by clear and unequivocal language. So you go read those cases, different controversies. Volvo motor manufacturer is one of the void for vagueness cases. Anyway, you read the cases that I cite because I learned a lesson from reading those cases. I'm not going to give you a bunch of stuff to research. I'm going to give you the results of a bunch of research that I did for years. And as I started out, I look back now and I did a lot of things correctly. I read a whole bunch of Supreme Court cases about my rights to privacy, my rights to contract, my rights to sue. You comprise your studies, take a month out and read a ton of cases where the government lost. When you're reading a case the government lost, you're learning about your rights against the government, and your rights won. Give me that. I got to read that. You bet. So read cases where the government lost. It's extremely important. At that same time,
and do you find a lot of the cases that the government loses, they seal them, or do you can pretty much find anything you want?
I mean the published ones, the ones they put in the law library where you got wall upon wall. Yeah, the ones that everybody has access to.
Right, but
And so
is there not a lot of them that they've sealed that they, would be really powerful for us to read?
I haven't run into any. No.
Okay.
So read cases that the government lost at the same time in tandem, because it was the IRS that ticked me off. I was reading dozens and dozens of cases every month on tax law interpretation, cases where the government lost and the government won, interpreting tax statutes. So I picked up a specialty along the way very early on, which was statutory interpretation. And if you're going to interpret tax statute, you got to do it a certain way. And the emphasis on the word certain, it's to be interpreted very strictly, every word, every punctuation mark. And when you get my tax work, understand that's my approach to it, is very meticulous and slowly considered points that come out of the statutory language at you. It's vital. And so in 1985 or 86, I wrote my own tax code, 60 paragraphs, that operates exactly like my findings about the chapters the IRS uses. I converted my findings into law of my own.
And what do you do at that point?
It was just another learning tool.
Okay.
It's like first I described it to you in essays, all these different modes of misenforcement. And then what'd you do, Dave? Oh, I briefed it and a bunch of people took it to tax court. Then what'd you do? Well, I got these learning aids that help people understand more readily what I'm driving at. When I say citizens of the US are only named in a regulation and not in a statute, the 16th Amendment says Congress can lay and collect this tax. It has to be a statute. You can't use just a regulation. And in wevgov.com/Orth, in that exchange of briefs, he makes this argument. You get the government's reply brief. They've had the argument at that time 27 years. And then you get the decision from the Seventh Circuit. They can't mention any of the provisions. So where are you? You're out in the cold. The law is a secret when you beat the government with it, because the law is played this way. Now it's your turn. Slap me. And you slap me. Law is played the same way. Hey, you broke the law this way, that way. Law's on my side. And if they just sit there and they can't even talk about the law you cited, you win, not in a tax case. This is a whole in due process. On takefromcaesar.us, scroll down the page a little bit and you'll see indented tax statutes, tax regulations, and then 3 conclusions that I prove with those provisions in briefed arguments. There, done. My whole treatise, 35 or 40 provisions, proving 3 things about the chapters they use to take money from us that totally destroys everything they've ever said to a citizen of the US. That's me. The law isn't written to apply to me, because you can't deny this, made of these 35 provisions. 35 provisions in 4 arguments in the Robert Orth brief destroy the IRS by confining it to its own statutory authority, pointing out the regulations that the Secretary of the Treasury wrote to say, no, we got a lot more authority than that. Can't do that with a regulation. The authority has to come from statute. I found some stuff because I was more careful and much more exhaustive in my research than anyone that came before me. Question?
And so you find that the government uses a lot of regulation instead of statute to progress these actions against individuals?
Well, if there were a lot of them, then there'd be a lot of needles in the haystack.
Mm-hmm.
There are only a few, but they're huge deviations from statute. I'll give you an example. As you read a definition in law, the term person means this guy, that guy, and this guy, but not the guy that paints houses red. Well, I'm a guy that paints houses red, so I'm not in that definition, am I?
No, sir.
Am I? Okay. The term person includes, the first time I said the term person means when they see the term includes, They say, oh, it's not a definition. It includes everybody, but especially the ones we listed. But I'm not listed, and Congress called it a definition, which means it lists everything it applies to. Your Honor, penalize this person for being frivolous. It says includes. We all know that the term includes expands the statute to include everything that would normally be within that term. So they enforce it as an inclusion instead of as a definition. A definition means I'm looking at everything they meant to mention. Now, you go to a definition in the tax code that does not use the term includes. The definition of citizen in Social Security, FICA, Chapter 21, 3121E. Permit me to drag it up here on, Cornell, 26 USC 3121. And I scroll down, I click on Cornell. I scroll down to 3121E, definition of citizen. If it mentions citizen, it's going to define citizen. If you go by statute, U.S. citizens don't owe it. I'm still scrolling to find subsection E. This is good. Here's C, D, and E, state, United States, and citizen. An individual who is a citizen of the Commonwealth of Puerto Rico, but not otherwise a citizen of the United States, shall be considered for the purposes of this section as a citizen of the United States. Well, first off, it's a definition. Secondly, but not otherwise a citizen of the United States, well, it excludes me. So I don't even need to know who it is. I just know it expressly excludes me. Shall be considered for the purposes of this section. Purposes of this section? Yeah, purposes of this section is definitions for the purposes of this chapter that imposes FICA on my wages, supposedly. And I go in here, I find a definition of citizen that excludes me. And it doesn't use the term includes. An individual who is a citizen of the Commonwealth of Puerto Rico, parentheses, but not otherwise a citizen of the United States, end parentheses, shall be considered for the purpose of this section as a citizen of the United States, and it doesn't use the term includes. So they wrote a regulation, and the regulation that implements this definition does use the term includes, so the prosecutor can cite the regulation to tell the judge, this applies to everybody. It uses the term includes. That's an expansive term. Well, it's not in statute. So if you go by statutes, citizens of the United States don't owe this.
So you're saying that the government is using the word include as extensive when it's in a regulation, but when it's in a definition, it's very limiting, correct?
Whenever they see it, it's expansive, but they can't see it in this statute, and they need to, because they needed to apply this to citizens of the United States. What are we going to do, boss? There's nothing in here that helps me apply it to a citizen of the U.S. Write a regulation, use the term includes. And so with a regulation that uses includes, they broadened this definition of citizen to include everybody they mention and everybody else. Wasn't that easy? It's so easy to be a public servant. Isn't that gross? Okay, so getting back to what I said, they're not going to give you tons of needles, but a few key needles. If you find them, pay dirt. So that's part of my argument against Social Security being applied to a citizen of the U.S. You'll find it on the federal income taxation page of wevgov.com. You'll find a video called Key to the Code on my YouTube channel called Take from Caesar. It's one of my first 7 or 8 videos. And it takes you through these same provisions that you see on wevgov.com to say, okay, I'm not the citizen in Chapter 2, Social Security Self-Employed. I'm not the citizen in Chapter 21, which imposes FICA for the employee and matching FICA for the employer. And I'm not the citizen in Federal Unemployment Tax Act in Chapter 23. And so Social Security is gone. And you're left with just Chapter 1 of the tax code for them to apply to you. They apply Chapter 1, normal taxes, capital gains, Section 1, the graduated income tax. Chapter 2, Social Security Self-Employed. Chapter 21, FICA and matching FICA for the employer. and Chapter 23, Federal Unemployment Tax Act. That's the end of what the IRS does to your pay, your compensation, or your capital gains. I just killed chapters 2, 21, and 23. The only one left is 1. Okay, so we go to chapter 1. Show me, citizen of the United States. Where am I mentioned in statute? Where does it say I owe this? They don't have a statute that says you owe it. So they wrote a regulation. You go to section 1 of the tax code, the graduated income tax, and it goes on page after page after page, bracket after bracket after bracket, page after page of tax brackets till you get to section 1H, capital gains. Whew. And nowhere in that entire statute that goes on for probably 10 pages, nowhere does it mention anybody's citizenship. So how do you say citizens of the United States owe the section 1 graduated income tax or capital gains tax?
Be a
Well, we won't talk
regulation.
about it. Well, we aren't going to talk about it.
Okay. We're not gonna talk.
Yeah, we won't talk about it, and we're going to penalize you for asking. And so I make the argument anyway, saying I'm obviously not Social Security. So that leaves just chapter 1. I'm not named in a statute in chapter 1, and the 16th Amendment says Congress can lay and collect this tax. Where's the statute that makes my citizenship liable for one of these taxes? So they wrote Regulation 1.1-1, 26 CFR, Code of Federal Regulations, 1.1-1. Who owes this tax? Citizens of the United States. Who's that? Any person born and naturalized in the United States and subject to its jurisdiction. Wherever they live? Yes, wherever they reside on this planet, they owe this tax. And I make the argument, and you have the government's reply after having had the argument for 27 years at wevgov.com/Orth. There's the exchange of briefs on this briefed issue. Read his opening brief for the appellant. He makes these arguments. Read the government's reply. Oh, we can't talk about it. After 27 years, I'm using just the law, the way I've always briefed it. You've seen this before. You probably got a room at the IRS devoted to these arguments.
So was this one of the cases that went to the Supreme Court? Is that what you're saying?
Yeah, the appellate court disposed of it and penalized him $4,000, and he did appeal to the Supreme Court. Certiorari denied. The Supreme Court will not hear these, even though they know you're being penalized thousands of dollars for asking just, or for using just the law. And Section 7345. It's newer than all my research. It's the one that says if you owe $50,000 and 1 penny or more than that to the IRS and you've been served with a notice of deficiency, you can't have a passport. And if you're offshore and you fail to respond to a notice of deficiency by going to tax court, they'll invalidate your passport and you're in another country. And you'll be lucky if they don't accompany it with an indictment. So you're in prison in another country. And that country calls up and it's Julio. Hey, we got your citizen over here. And the government will just say, keep him 60 days. We'll get back to you. So they know you're in jail eating rice and chicken off a piece of newspaper in the jail with the local drunks and knife assailants and the rest of them in some, crap hole in Central America, or we're going to Costa Rica. There's no right to a speedy trial in Costa Rica. What are you going to do? You're going to wait for your government to act. Yeah, we'll come pick them up in 60 days. So you're in a Costa Rican jail for 60 days, maybe in contact with your people, maybe not. I don't need to put that kind of a tool in the hands of the government that'll keep the law a secret. And so before I can travel, I have to get back in the system. Or all they have to do is say, he owes $50,001, jerk his passport. And what are you going to do? You're going to sit in jail, a foreign jail, in another language. Yay. With cockroaches or without. You might get your choice.
And so what do you do in that scenario?
I'm getting back in the system. I'm going to hire somebody to say, and I teach people to do this. This is how I keep people out of prison. You go to H&R Block or somebody else that's really big, and you say, all of my records are this. I need a worst case and a best case scenario for my bacon if I were to ask you to get me back in the good graces of the government. And they'll go over all your figures. They know what the IRS will do for them, what they won't do for them. And they'll say, well, you'll be lucky to avoid indictment. You've been filing Pete Hendrickson tax returns. Oh, holy hell. Or you might just have skipped a couple of years, and I think we'll be all right with all this. And you'll pay X number of dollars in penalties. And how soon could you get those paid off to keep them from breathing fire on you? And then they'll go with you to the IRS and meet with a special agent and get you smoothed out, get all the signatures, and get what's called a global resolution. A global resolution means you satisfied all the requirements right up to this date, and we hereby waive rights to mention anything before today's date when you're paying your penalties, filing your returns. Forget everything else. We're on an even keel. Don't forget to file next year. Great, thanks. That would be a global resolution. And so you can travel. But our government is up to doing the very worst things to you. Don't push them. And I'm the one that keeps people out of prison. Pete Hendrickson and David Champion, they're the ones with their ilk who land people in prison. I'm focused on preserving liberty. That's my main cause. Go ahead.
And so we've covered a lot of grounds. I've been making notes, but I don't know if we have time to go back for all this even. But the people that don't file, they could just say you owe $50,000 and take your passport away. Is that what you're saying?
They can't lien or levy you or sanction you until you've received a notice of deficiency at your last known address and failed within the next 90 days to petition tax court.
Okay.
And then it's game on.
And so, of all the times that you've entered the courtroom, what percentage would you say you're on defense? What percentage you were the plaintiff?
Since 1994, January, the first briefs of my life went to tax court. And I took 5 of those people all the way to the Supreme Court by October of 98. One of them came up through a state tax court, Oregon. And that was all on paper, through the mail, meeting deadlines, writing against IRS attorneys, and then on appeal, writing against DOJ tax division attorneys, all of it through the mail, meeting deadlines with photocopies. It was in another century. No PDFs, no electronic signatures, no email. And, you got a stack of documents in your hands and you're going to the mailbox with them, or post office. So then into state law, and it was all still through the mail because my arguments are mostly statutory. I did write some arguments for people to take to court, but they weren't necessarily local to me. And I only went to court a few times on my own controversies. So in court was actually very small in the overall picture.
Mm-hmm. Well, are you hopeful now with the new makeup of the Supreme Court that they may hear some of those things? If you had to do it all over again, you think the Supreme Court would be a little bit different, or you have little hope in that either?
Brett Kavanaugh said something. If you come into my court and you have the better legal argument, you will win. So I quoted him. In 2018, there were 3 clients, 7th, 9th, and 11th circuits out of U.S. tax court that I wrote Supreme Court petitions for. So I tried that out right away. And I quoted him right there in the Supreme Court petition. If I have a better legal argument than they do, I win. Well, look at the appellate record. They can't even talk about these provisions. And you still lose. So, no, I have no faith. I have no confidence. My radio shows and conference calls have forever been called No Confidence. I was the first one to own noconfidence.com. And all the government does is uphold my wisdom as irrefutable truth whene'er I happen to interact with it.
And so do you think that if you're taking a case that is outside of the realm of taxes, that you have a better chance, or do you think
yes, and one example of an advantage is criminal complaints. If I'm going to court to complain about misenforcement, were they after your privacy, your liberty, or your property? Oh, they're after my property. The cop falsified the police report. First thing I do is go to the criminal code and I choose the statute I'm going to write a criminal complaint under against that cop. You didn't hear me play defense first. File a motion to dismiss. No, I'm going to file a criminal complaint first. And I'm going to put that with its exhibits behind my motion to dismiss and file that into court so the court knows I'm going gangbusters after this cop's career.
Do you file these criminal complaints with the local district attorney, or
it depends on the lay of the land. If it's a superior court prosecutor that committed it, I'll probably file it with the next county's DA. If it's a local prosecutor, a local cop, I'll file it with my county's DA. It's not a terribly important question to ask, but go to your state's Commission on Judicial Performance, Commission on Judicial Conduct. They're going to have a website saying, we're a committee, we're at work, policing the bench, and here's what we did to this judge. Here's another judge. Here's another judge. You open up those files, and there'll be papers in there written by the panel in the commission saying, we found the way they acted toward this attorney acted greatly to discredit the attorney and might threaten future employment opportunities for that attorney. What the judge should have done was called a sidebar instead of critiquing the attorney in open court for everybody to hear. And so we're giving him 6 weeks without pay or kicked off the bench for 6 or whatever. There will be a sanction associated with the misconduct. Well, if you don't like a particular judge, go to that website and download some reports about certain judges and their misconduct and put them as different exhibits behind your own mandatory judicial notice and offer of proof that says the court should be aware and you're hereby on notice that I don't trust judges. See exhibit A, B, C, D, and they're right off the website where judges are punished. That's how do you like me now? This one is really important, folks. You got to write this down. This is pure fun. And it traumatized the judge. Go to takefromcaesar.us. Takefromcaesar.us. At the top of the page, there's a left to right picture of a Federal Reserve branch, gray, concrete, black, bad weather. And right below that, you see a couple paragraphs side by side. And right below that, there's a group of links in the middle of the page. Those are particular pages from wevgov.com. So you could go to my federal income taxation page in that group of links. You can go to my page on citizen's arrest. If you identify a felony, coast to coast, you can arrest that person. So why wouldn't you want to know when a federal public servant has committed a felony? Come on. Anyway, click on the one that says play offense. Play offense. It takes you to a page, pops up, it's black, and it's about a false arrest for contempt of court. I got a phone call on Monday afternoon. Hi, Dave, this is Craig. Hey, I got Al on the line. We went to the hearing this morning that I told you about over the weekend, and he was arrested for contempt of court. I said, that's terrible. What a heathen. And he said, no, the judge told him last week, I find you meant this is the judge that would not properly arraign him under court rule. And the judge was stonewalling, and he was headed for jail. A tattoo parlor owner that they wanted to steamroll out of town. If you plead guilty and move your shop out of town, no jail time type of thing. And the judge says, I find you mentally incompetent. I want you to go see these professionals, Dr. Smith and Dr. Swanson, to get a psych evaluation. And your next hearing is next Tuesday at this time in this courtroom. So he gets a letter from his own psychologist that says, Al's just fine. And he goes back to court the following Monday, and you can hear the hearing in the audio of the tutorial on that page. His hearing was only 2 minutes long. And the judge sits down, Mr. Centraletti, I've got this letter here from Dr. Jones and Dr. Joshua that says you didn't go see them. Do you have an excuse for not going to see them? He says, yeah. Do you have an excuse for not recusing yourself? She says, remand him into custody. And 2 deputies take the cuffs out. You can hear the cuffs go on him and everything. And he's griping as they haul him out of the room. What's wrong with this picture? Well, allocution is a constitutional right. Allocution is, before I impose contempt sanctions, is there anything you'd like to tell the court that might ease punishment or prove you weren't in contempt? Well, she didn't give him that opportunity. So, bingo, she deprived him of a constitutional right. Number 2, bingo, she had help. That makes it a conspiracy against his rights. They're using the mail to get him into court. That makes it a federal violation of mail fraud law, 18 U.S.C. 1341, 20 years in prison, frauds and swindles. That's a federal felony. She can be arrested. Judge Lisa Novak. So can the 2 deputies that denied him of his right to allocution. Was he in contempt? I don't know. First, she tells me, go see Smith and Swanson. And the next Monday, she goes, how come? Do you have an excuse for not going and seeing Jones and Joshua? Yeah, those aren't the 2 doctors you told me to see. That's a pretty good excuse. And if you'd have just let me allocute, I'd have told you that. And so on that page, play offense, scroll down and you'll see the filings in PDF. It says all in PDF. And that's the whole filing with signatures and everything. And below that are the documents in Microsoft Word. So you get them in Microsoft Word if you care to use them. None of this is legal advice. But listen to the interview of Craig, the court watcher, who had gone to all of this guy's hearings, and he knew it was a railroad, and he'd been studying my stuff, so he knew how to spot misconduct. And he says, yeah, I got Al here. I had to pay $800 to get him out of jail. And here's what happened. He wasn't in contempt. Those weren't the 2 doctors. And he didn't get it. And they threw him in jail. I had to bail him out. I said, did you record the hearing? He says, yeah. And this is in 2007. We were just breaking out of the previous century. I said, send me the cassette tape. What's an MP3? And so they overnight me the cassette tape of the 2-minute hearing. I get it on Tuesday afternoon, overnight mail. I listen to it to make sure I got my feet on the ground. And I started writing the criminal complaint, the petition to convene a grand jury to hear a complaint for an indictment against the judge, and then a federal criminal complaint, and then the notice to the municipality, the county that pays the bailiffs, hey, we're going to sue you in federal court. And then an affidavit of prejudice to go on top of that he then filed into his own case to get the judge to leave the case. And the following Monday, he shows up, the following Tuesday, I think, following Monday, maybe, he shows up to court, and they're in there before the judge came out. And listen to the court watcher, Craig, describe the judge's demeanor, because he filed all this stuff on Friday. And so she's had all morning to study it. And he says she comes into the court like she's strapped to a board, turns toward the audience, sits down like a robot. Good morning, Mr. Centraletti. Your rights are very important to us. The court wants you to know that we'll always fight to uphold your rights. I've assigned this case to another judge. Your next hearing is Monday at this time in this courtroom. Stands up, turns like a robot, and walks out. And before that, she was the Wicked Witch of the West. And he said they left the courtroom and made it to the front door of the courthouse, the front step, and just collapsed laughing right there on the courthouse steps, laughing at that judge. And they said it took them 5 minutes to get back on their feet. And they walked to the car, and he turns on the engine, moves away from the curb. He said he was still dangerous behind the wheel. He was laughing so hard, tears running down both their cheeks at what those documents did to that judge. Totally within the box, exactly as a good lawyer would write them. And it burned the judge over happenstance, contempt of court. Why didn't you go to see Jones and Joshua? Well, because you told me to see Smith and Swanson. Let's start there. So the target was huge. But I told you I'm keen on criminal complaints. Read the one that I wrote against her. Read the federal one and understand when I say I got courses about writing and filing criminal complaints, this is the kind of stuff you get from me. I want them to walk home with a cloud over their head, just like they do to us.
Yeah, well,
The guy was
so walk us through a little bit of the criminal complaint. So you filed it in the court, right?
yeah.
And the judge
Okay.
got scared there, or I mean,
No,
who?
no, 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 no.
Okay,
They didn't. They had no lawful authority to touch him, did they? Because he
no,
wasn't in contempt. Okay, good. So that's assault.
sure,
So
but
I want to look up the California assault and battery statute, and then they took him away. So I want to look up the California kidnapping statute, and I want to write a criminal complaint for extortion of the $800, the battery, and the kidnapping against the judge and the two deputies. And I want to put those accusations in a state criminal complaint. And on top of that, I put the petition to impanel a grand jury, and they filed it in a court across the county, not in the friendly court.
gotcha.
And then they took their stamped copies remaining and put the federal one on top of those and went and filed it with the FBI and got their remaining copies stamped by the FBI. And then took the notice to the state, to the county treasurer, saying that we're going to sue you in U.S. District Court. You better settle now, and got the treasurer to stamp all of his remaining copies received, and then put the affidavit of prejudice on top of that and filed it into his case. So the judge could see everywhere he was filing a criminal complaint to get her into federal and state prison. And she was wrong.
And so if let's just say the FBI refuses to stamp your paperwork, or the AG decides not to,
Take a witness that can sign a certificate of service. I won't take no.
okay. And when they filed it in the neighboring court, right, the neighboring county court, what do you file a new case, a civil case that way, or how does that work?
It depends on whether or not they choose to put a docket number on it, but it's a criminal case. It is not a civil.
But do you have that? Do you have a right of action to prosecute that?
No, the state has all the rights for justice. So these people that plead, hey, if you give them that sentence, they killed my son. Where's my justice? You don't have a right for the state to visit justice upon them. It's the sole discretion of the state. And so you can't complain that you didn't get justice. Justice is not yours. Justice belongs to the government. It feels good, and so you could say I received justice, but it's not because you deserved it. It's because they deserved it and they received it. And then you can walk out and go, all right, can't wait till he meets his cellmate, but it's not your right.
Gotcha. But you have the right to arrest them, right? Is that what you're?
If a felony has been committed, you want to look at different states' laws concerning felony arrest of a citizen's felony arrest. And I have a whole page, all the excerpts in 2012 that I found in the LexisNexis database. I have an excerpt from each of those cases on my citizen's arrest page. Go to your own state's law, find your citizen's arrest statute. In California, it's been so messed up. Best of luck. They've got, since 2012, they've got like 1,500 citizens arrest federal cases. So California is a time warp, but Washington is very clean. It's easy to understand. It's very little doubt whether or not what they did to me was a felony. And therefore, for the statute of limitations on that felony, I've got the rights to arrest them. 5 years. Anytime during the next 5 years, anyone in the nation can come here and arrest you if they found out about your felony. Some states require that the felony be committed in your presence. Now, let's take a look at a very specific felony. I've never heard anybody else put these two together. 18 U.S.C. 241, conspiracy against rights. If any two persons conspire to threaten, injure, or oppress somebody in the exercise of rights under the Constitution or under a statute, bingo, 10 years, federal felony. 18 U.S.C. 1201, kidnapping. If a person, it doesn't say if two or more persons, if a person seizes, inveigles, confines, decoys, and hauls away and holds for ransom or otherwise the body of another person, they can get up to life imprisonment, kidnapping. If anybody unlawfully seizes, inveigles, confines, transports, hauls away, and holds for ransom or otherwise. That's our definition of kidnapping, isn't it?
Right.
Okay. Then you go back to 18 USC 241, the third clause, and it says, if the conspiracy against rights involves a kidnapping or an attempted kidnapping, you could get the death penalty. So if two or more persons conspire to falsely arrest me or steal my money, whether they're, I didn't see an exception in the statute, says, unless they're a public servant, there's not an exception. If two or more persons do this, well, you falsely prosecuted me. You threw me in jail on a charge you knew was false. How is that not a capital offense?
Right.
All the cops on scene knew it. All the cops committed the act, and they knew I was innocent. They're capital offenders.
So
Nobody
walk,
I've just a second.
Okay.
Nobody I've heard has put those together. Capital offender, my right to arrest a felon. Capital offender. When does the statute of limitations run out on a capital offense?
Isn't it by state? Or no?
It's permanent.
Or never?
They can prosecute you for kidnapping for the rest of your life.
Okay.
And conspiracy. It's a capital offense. And so it's like murder. There's no statute of limitations on it. And so for the rest of my life, I can arrest you, servant breath. And so I've become a different citizen than anybody else they meet.
Right.
When would be a good time to arrest you, Your Honor? At the volleyball game your daughter's going to have at the high school, maybe at the awards banquet for judges. Where would be a good place to arrest you?
And so you arrest them, and then who do you turn them over to?
I didn't say you arrest them.
Oh, okay.
I said you confront them.
I gotcha.
And see if they're going to puff up their chest, and the cops step in. Better leave them alone. Well, yeah, that's what I thought you'd say when I have a right to arrest them. You stepped in my way, officer. Officers. Let me see, officers. That means more than one of you. A conspiracy against my rights to arrest a felon. You're now capital offenders. Okay? You keep this tool at your ready. Think about it. A felony, right to arrest them. Capital offense, a conspiracy involving a false arrest, that's forever. Anybody that wants to in the United States, officers, can come here and arrest you with all necessary force under this state statute we got here. See how I can just turn it right around on them? I told you early on, I only help innocent people. So when innocent people go to jail and you can prove they were innocent and that everybody should have known, criminal complaints first, and talk of felony, citizen's arrest, and then you put all those exhibits behind your motion to dismiss.
So walk me through a person is out on the street, they get falsely arrested, thrown in jail for whatever, 36 hours or 24 hours, whatever it is. And right. you write a criminal complaint, kidnapping or whatever, and you turn it into the local DA, and they say, we're not doing nothing about that. What?
Fine. Point me toward the door you want me to bring them to when I arrest them.
And so, do all states have citizens arrest? Because I think Louisiana does not have one.
Look at that list of decisions on my citizens arrest page. You'll be hard pressed to find a circuit where it doesn't exist. It's a common law right, regulated under state law.
And do you recommend arresting anyone?
I recommend you confront them with your right to do so.
Right.
They might not like it, and you can't predict corruption. So frame everything as a question. When would be a good time to arrest you? Are you threatening me? No. Did you hear any first-person threat to commit an act of unlawful violence? No. Well, then I didn't threaten you.
Gotcha.
You have to know what a threat is too. Hang on. On takefromcaesar.us, you have that first group of links in the middle of the page. Near the top, scroll down, and you come to a check for $25,000 made out to me. Right below the check, two groups of links, one on the left, one on the right. The group of links on the left has one that says, don't say threat. Click on that, and there's a tutorial about a false prosecution for somebody that says they're going to arrest somebody. So that audio will take you through that page, and you can acquaint yourself on what is and is not a threat. It's called a true threat, a first-person context. I will break your toe when I see you next time. Unlawful violence, I'll break your toe. Interstate communication, I set it over email. There's an interstate communication of a threat to kidnap or injure. Those are the essential elements of that statute. And so if somebody says, "You trying to threaten me?" Where'd you hear a first person threat to commit an act of unlawful violence? I asked you a question. I asked you, when would be a good time to arrest you? I don't pay public servants for evasion. Answer the question. When do you want to be arrested? It totally levels the playing field conversationally. You pose it as a question, they can't say it was a threat. So right up against them. When would be a good time to arrest you? Who in your family do you want to? At 3 o'clock Christmas morning in front of your Christmas tree in your living room, would that be a good time? Get on the ground. Okay. These rights exist. It's not my fault. And I've got all the judges in the world to say, citizens arrest. Oh, yeah. And it's all available. I got the information on my websites is so deluxe and densely packed. You could get into them and people won't see it for 6 months, but you'll come out with an understanding derived from what judges taught me about the law. My education comes from case law. You can't read too much case law. And I don't want to say, hey, it's my opinion. I'm Dave. I want to be able to say, it's this circuit court's opinion right over here. Yeah. So back to the question, servant. Don't run away from me again. And you walk taller than you do without this information.
Absolutely.
And when you get the flash drive, it's only $200, and it includes a bunch of audio tutorials where you hear me speak about why I do what I do and the reactions I get from public servants. It's like you walk a fine line, but walk a line where the prosecutor knows, no, hey, don't arrest him. He'll come in here and he's going to sue people. I know this kind. Okay. And you want to be the kind where the judge will tell the prosecutor, don't bring him in my courtroom again unless they're breaking legs and burglarizing homes. I don't need the guy in my court. That's who you want to be. Because usually with you and me, they're just after money.
Mm-hmm.
And the flash drive also has a deluxe course on criminal intent. I don't believe I have a duty, and they can't put it on record how the motor vehicle code has been written to apply to travelers. I have the 1910 version of our motor vehicle code, and it says only commerce. Where did the legislature signal an intent to broaden the scope of the motor vehicle code to include travelers? They can't come up with it. So they can't prove the motor vehicle code applies to you. It's time for a criminal complaint. Racketeering. So Kurt Riggin and I filed March 9th of 2006 a racketeering complaint with the Department of Justice. And you get the course on this on the flash drive, a racketeering complaint against everybody in Washington state that's misenforcing the motor vehicle code. Racketeering, conspiracy against rights, filed with the federal government. So I walk the walk. I do what I do. And you can't predict corruption. They might arrest you, but you have to be ready. Criminal intent, there's a course on it. Study it, read all the case law, and consider David Toulis in Chattanooga, Tennessee, right to travel. He's got this license plate and he gets busted. He gets arrested, and they let him out right away because he's a real spark plug, got his own radio show in Chattanooga. And Nooganomics is the name of his show. Nooganomics. He's the star of Chattanooga. And they prosecute all these people for right to travel criminally. They prosecute them.
What's David's last name?
Tennessee, Chattanooga, Tennessee.
His full name?
David Toulis. Toulis.
Got it.
And his people go out driving right to travel with a private license plate, and they still get busted for crimes when it's obvious they don't believe they have a duty. That's one of the definitions of innocence. Go to Take from Caesar on YouTube, my YouTube channel, and there's one of my tutorials is called Definitions of Innocence. If you don't believe you have a duty, you don't have one unless they can show it to you. They have to overcome your belief before they can say you possess criminal intent. If you don't possess criminal intent, they lose. All the case law says so. When it comes down to it, the traffic court judge will ignore it. The county and city judge will ignore it. saying, I got all the proof in the world, I don't believe I have a duty. It won't matter to them. And so criminal complaints. This police station knows I don't believe I have a duty. I have this stack of paper that I filed with you over the last 4 years. You never came through with proof I have to have a license plate. And so how do you now arrest me and say I have criminal intent when you can't deny that I have this right, that the scope of the motor vehicle code doesn't extend to me? You want to write this down too. This is very important. Reliance defense. Hey, I relied on what my attorney said to do. I relied on what my accountant said to do. I relied on what the sheriff said to do, or the prosecutor. I relied on somebody. And
a
that's my
Supreme Court case,
defense.
would that work?
Anybody you relied upon, if they have any authority whatsoever. So I have this defense in my reliance upon reliable sources of information. It's not called a reliance defense. It was always called reliance defense when the Research Foundation of Honolulu did it for tax criminal charges. But the legal word for it is entrapment by estoppel. Entrapment by estoppel. And you'll find a million cases fit right into it. And people actually lost. They were criminally charged and they lost. They went to jail. Entrapment by estoppel. U.S. versus Talmadge, I think it was 1997, maybe, Ninth Circuit case, Tallmage. Talmadge, state felon, you can't own a firearm. And he heard that the state government reduced his state felony to a misdemeanor. So he petitioned the court for recognition that his existing conviction had been reduced, along with all the other people that were penalized under this felony statute. And the court declared, okay, it's a misdemeanor. Don't buy a concealable weapon. That's all the judge said. Didn't write it down or anything. Then he asked his attorney, he says, I could buy a gun now, right? The attorney looks at his stuff. He says, yeah, misdemeanor. You can buy a rifle. So he goes to a federal firearms licensee, an FFL, gun shop, and says, my felony was reduced to a misdemeanor, and here's the paperwork and the judgment. Can I get a gun or what? And the guy said, yeah, you can get a gun. And then he was convicted for felon in possession of a firearm. And he gave the court all the evidence and lost and appealed it to the Ninth Circuit. And the Ninth Circuit said the federal firearms licensee is deemed to be an expert on firearms law. And he told you you were eligible for a gun now. And your attorney told you, but not in writing. And the judge told you just in passing and not in writing. And so your conviction violates due process. You were entrapped by the advice of others. It was a reasonable effort. You came out with a conclusion that was theirs. And so you didn't really have criminal intent. Conviction overturned. Well, here am I. I've relied in a tax case. I relied on hundreds of federal appellate judges to make my arguments, innumerable Supreme Court justices, hundreds of legislators that passed these statutes, and bureaucrats that wrote these regulations that I've obeyed with and used in my arguments. And you're still going to put me in prison for tax evasion? How is that not entrapment by estoppel? My authorities were way more convincing than a federal firearms licensee, a private attorney, and the judge in passing. And they still won't give you the case. They'll send you to prison. But there's an example of an argument you might make if you're on file already with the cops to say, I don't have a duty under that motor vehicle code, leave me alone. And then they don't. How is it not a false arrest when they know you don't have criminal intent? It's a false arrest. Let me give you Gasho versus U.S. GASHO. Get ready to write the case site. This is wonderful. I go to takefromcaesar.us and I want to go to don't say threat. It's under the picture of the $25,000 check, left-hand side, don't say threat. 2/3 of the way down the page, I look on that page, and here's U.S. versus Gasho. Gasho, Sharon and her husband were flying an airplane that the federal government wanted to confiscate. And so the Fed was there at this private airport where they were going to land the plane, and they were there to seize it. Hey, this is our plane. Here's the notice. Okay, go for it. And they said, do you have any personal effects on the plane? And Sharon goes, oh, yeah. And she goes back into the plane and picks up her purse or whatever and the log books for the airplane. And she was indicted for intending to defy and frustrate the seizure by taking the logbooks. Well, when she came off the plane, her husband said, did you get the logbooks? She says, yeah, it's good. And they walked right past the Fed with the logbooks and left. And the Fed took the plane and then indicted her and charged her with defying or frustrating the seizure by taking those logbooks. And on appeal, the Ninth Circuit, 1994, it is fundamental that a person is not criminally responsible unless criminal intent accompanies the wrongful act. 1952, Morissette. Consequently, to have probable cause to believe that a crime has been committed, an arresting officer, not this arresting officer, an arresting officer would have to reasonably believe that Sharon Gasho intended to defy and frustrate the seizure at the time that she removed the logbooks.
And this is mens rea, right?
It's what?
Mens rea.
Yes, criminal intent, mens rea. And so take it to another officer who possesses proof that I don't believe I have a duty under the Motor Vehicle Code. Consequently, to have probable cause to believe that a crime has been committed, this arresting officer of mine would have to reasonably believe that I intended to violate the law that requires me to have a license. Strike three. They've been ignoring it for decades.
Mm-hmm.
And if you've got paperwork on file with them showing I've got a certain take on the law you haven't rebutted, and it's statute, it's written law, it's state law, Motor Vehicle Code, I'd like to know where you get off cuffing me, taking me to jail when you know I don't believe I have a duty. I have to have criminal intent for you to touch those handcuffs. Period. Okay. I don't file my motion first. What do I file first? Criminal complaints. He knew I was innocent and he cuffed me and took me to prison. Well, that's a kidnapping, not a conspiracy. There's only one of them. But if there's two of them, that's a conspiracy against my rights. You're capital offenders. When would be a good time to arrest you? And what's your badge number? I got to put that in the motion. And then you file your criminal complaints, the proof that they knew you were innocent, and then you put those on record behind your motion to dismiss, and your trial suddenly becomes their trial.
Nice.
Because you didn't tell a lie, you told it how it was right there in the criminal complaint. You're going to stand on those facts for the remainder of the proceedings. Oh no. What are you going to do now, officer? You're going to get your hands up against that wall at the volleyball game when I go to see your daughter play. Ha ha ha. It's a different game when you know your rights.
Mm-hmm.
You learn your rights by reading case law where the government lost. Now, I got to tell you of another trick.
Now, if let's just say that they didn't file any charges against you, they just release you. So you're not in a criminal trial. The only action you could bring at that point would be the civil. You can't file.
They arrested me on suspicion of a criminal, so
right.
It was good enough. It was good enough to arrest me.
But in what
doesn't
court?
have to be a successful charge. It just has to be I was wrongfully arrested. That's a kidnapping. They took me away for ransom or otherwise.
Well, right. So I could see that, if they're charging you with a crime and you're in criminal court basically for your fines or whatever you're arrested for, and but if they don't proceed with any court hearing, you don't have to put a motion to dismiss in at all. They've just dismissed the charges. Then where would you file that criminal complaint to do that, right?
I'd file it right in the same court. That officer's probably in there every other day.
Okay.
And the cop probably knows the officer by name.
So just file, whether you have a case or not, you just file it in that court?
Well, crime's been committed.
Right. Okay.
So yes, I file it in that court and let it heat the court through the winter time. Visit it from time to time. Visit the prosecutor. When are you going to get this guy in handcuffs?
Right.
Come on, I'm hot to go. I want in jail, in jail. You never cut me any slack.
Yeah.
Okay, and be belligerent, especially if they dismiss the charges.
So, I'm sorry. I'm just a little bit trying to clarify for the audience here, and myself. If you file it in this criminal court that they haven't charged you with, then wouldn't you be having to lobby the prosecutor or the DA to go after him? Is that it?
When I file it into the court, they may place a criminal docket stamp number on it. But it's their problem. I'm doing it just because I know no one's going to jail. The cop will never get in trouble, or
Well, sure.
I'll make as big a beef of it as I have to become a real pain.
Right.
So they don't talk to me again. If you don't like the way that feels, officer, put your pen away. Get a grip.
Right. I'll
arrest you in front of your children. Thanksgiving dinner. Get up against that wall. Right, everybody?
Yeah.
Sister-in-law of this cop? Yeah. Am I right? Okay, and just walk right into their family.
Mm-hmm.
Yeah. Why not? Cop on the job. Hey, I got the rights to arrest you. Shut your patrol car off. Take your gun bev off. Put it in the back seat. You're coming with me. Yes, I have pepper spray. And when you know your rights and stand just on them, and you don't make a threat, instead ask questions, would now be a good time to arrest you and whip them into a frenzy over the fact they broke the law.
Mm-hmm.
Not my burden, not my fault.
Well, let me ask you, what is your opinion on bar complaints, and what effect does that have, if any, on anything?
Since I file criminal complaints, I'm usually complaining more belligerently than in the system attorney or prosecutor would want to pick up and dribble. So I don't count on getting anywhere. At the most, I might get somebody fired. An example of that, if you went to the John T. Smith shooting on Wikipedia, John T. Williams shooting. John T. Williams, member of a loose club of wood carvers downtown Seattle. I think he was homeless. He was a Native American, and he was sitting on the curb whittling a piece of wood with a 3-inch knife. And Seattle police officer gets out of his car, draws his gun, draws it down on the guy, and says, "Drop the knife." And John T. Williams goes, "What? Drop the knife." And he stands up and he goes, "What are you talking about? I'm sitting here whittling a piece of wood." And the cop shot him twice, killed him right there in broad daylight. It was like noon, downtown Seattle. That cop was allowed to quit and leave town, and the shooting was deemed unauthorized. Those are the worst of the sanctions that were doled out. Killed somebody. So no, you won't get a cop in jail. It's not going to happen. Michael Idland was a Washington State patrolman who, on duty, swing shift, would stake out nice lounges, and a pretty lady leaves the lounge, gets in her car alone, and leaves. He'd pull them over in contrived drunk driving stops and manually molest them when searching them at the car. "Oh, we got to go back to the station with you." And they get back to the station, he'd molest them again. And an FBI agent interviewed 7 victims and wrote down the notes of the encounters. And he was in custody pending trial in King County Jail here in Seattle for 18 months, year and a half, and then was released, time served, on a gross misdemeanor. And all the while he was on administrative pay. And since it was a gross misdemeanor, like custodial interference, he didn't have to register as a sex offender the rest of his days. And those were the favors paid to him by Judge Palmer Robinson. So I'm not excited they might go to jail. I'm excited I might get them transferred. Probably won't get them kicked off the force, but I might get them transferred. Tell the sheriff, I'm going to arrest him next time I see him. Get him off the force. Get him off the force. If I see him in a patrol car, I'm going to arrest him. Suddenly, since you got the law on your side, it's a little bit more of a sticky wicket than the things that they actually do put cops in prison for. Shades of New York.
Yeah.
Abner Louima. God bless him.
Man.
Now, the page about the judge and the false arrest for contempt of court is very funny. Listen to the 60-minute audio, which includes an interview of the court watcher, the 2-minute hearing where the cuffs go on, and my interview of the court watcher. And we had a blast. They falsely arrested the guy, and I turned it around on the judge. It just burned her. And the next judge comes in the week later. Just as I said to these guys, the next judge is going to come in and say he's going to try to calm everybody down first, because he's going to look at that paperwork against her and say, I don't need a document like that on file against me. I don't want my name in a caption. So he comes in, good morning, Mr. Centraletti. How are you today? And this public defender, Centraletti didn't even ask for, pops up out of his seat and says, good morning, Your Honor. I'm so-and-so here to represent Mr. Centraletti. I'm from the defender's office. Listen, it looks like there's been a violation of his speedy trial rights and all this messing around, failing to arraign him. They'd gone week after week after week without arraigning him. And there's a limit on that. His speedy trial rights have been violated. And the judge looks at the prosecutor and says, is this true? Meaning it was totally scripted. And the prosecutor says, I'll get back to you this afternoon. So that afternoon, the public defender called Mr. Centraletti and said, they're dropping the case, speedy trial. Cool. So it's just a matter of getting rid. My only assignment was to get rid of that judge. And I did it with a criminal complaint for kidnapping, stunned her. And she got off of that case. The next judge comes and says, hey, good morning, to a guy that had tattoos from head to toe. He probably had tattoos in places you can't see in the shower, piercings everywhere. One of the spectacles you see on Google, and he beat the charge. So my only assignment was to get rid of that judge and look at the paperwork I chose to write to do it. A lady, one of my students, California, got sandbagged by the local county court and was sent to jail for a 30-day psych evaluation. And she was really stressing out. And her boyfriend that she lived with calls me and said, hey, she's in jail another 30 days. Got any ideas? And she was already able to write her own civil rights lawsuit. So she was already a good student to work with. And I said, well, she's in jail. She needs something to keep her mind off of it, definitely. And I thought of everything I had that she might be able to use to put together motions or whatever. And he asked me, what's the quickest way to get this into the jail? I said, if you mail it, it could take forever just to reach the jail. So if you mail it, it's got to go in the mailbox on the sidewalk closest to the jail, might be a block away or whatever. Or you could, because if they get it and you're not an attorney and you sent that to it, they can read it and they can obstruct its delivery for another week. So you need to get it to her right away. And so why don't you do this? Write up, go to small claims court and get one of their forms off of the wall there and write a small claims lawsuit against her that's bogus, just a paragraph or two saying, hey, I live with her and I'm suing her because in this house, we split all the bills, the electric bills, so forth. And lately, she's been leaving the refrigerator open. She leaves the lights on. I'm not a rich guy, so I'm suing her for compensating me on the electric bill $1. So you stated a claim. You're suing her for $1. And then after that, put, I can't believe she'd treat me so rudely and mean, considering all the legal work I've been doing for her lately. Exhibit A, B, C, D, E, F, G, X, Y, Z. And it's like 350 pages, 75 pages of blank pleading paper. A briefing under California court rules for discovery, whatever. All the stuff I knew I had that might be able to help her while she was in jail, and put it as exhibits behind this small claims civil complaint. I said, now go file it in small claims and then call the sheriff and have him serve it. And the sheriff comes back and gives him a certificate of service and says he's allowed to walk right into the jail and put it hand to hand right in her hands. How's that for immediate delivery?
That's clever.
It wasn't even challenged. Come on in, officer, and he hands that lawsuit right to her. Nobody in between.
Nice.
Anyway, I won't take no. I don't take no. I'm here to cause problems because I wasn't causing a problem and they brought one to me. I'll bring one to them.
Well, let me ask you, we have a lot of problems with judges just refusing to rule. And not just in my case or our cases, but across the board, they're just stall tactics. And a lot of them are federal, so they have broad discretion. We got it. What are your tactics? What would you do?
First, limit their discretion. 5 USC 706.
Okay.
The Administrative Procedures Act, Marbury versus Madison, and cases since then that say the same thing, that in this republic, the role of the judiciary is to say what the law is. 5 USC 706 instructs them on how to say what the law is. When presented, the reviewing court shall decide all statutory and constitutional issues along these lines, and the court shall set aside everything outside the agency authority, in excess of its authority, violates due process, or order the performing of a function that's been unduly delayed. There's a whole lot of latitude the court loses if it were to comply with that statute. Find your own state analog, your state Administrative Procedure Act, if you're in a state court, and cite that as far as what the judge has to do for me. Because if they don't do for me what the law says they have to do, equals damage. It equals official misconduct. That's a crime. Gross misdemeanor in Washington. Colorado has first and second degree official misconduct. If a public servant engages in unauthorized conduct or fails to perform a duty imposed upon them by law to deprive somebody of a right or privilege, gross misdemeanor. Washington State, that's a year in jail max, $5,000 max.
And so you write a criminal complaint against them, and
if they don't do what my Administrative Procedures Act says they have to.
Okay.
And in a tax case, you'll never get the law. They'll never do it. They will not interpret the law. So I hit them with that statute and then accuse them of dereliction and an affidavit of prejudice. You won't even comply with the law. I got rights in this statute and you won't give them to me. Quit right away. And you take the offense from their misconduct and stay on the offense.
And so would you ever recommend threatening the judge with theft of services for not providing the services that you paid for?
No, that sounds like it would be hard, theft of services, but it's probably down in the ranks of gross misdemeanor. So you're not playing hardball. You're not asking for the moon, alleging treason. Nothing lofty here. Just garden variety crime here. He's no better than the defendants he sees all days. So why don't you suspend him for a few weeks? Complain to the Commission on Judicial Conduct. If the judge has a license to practice, complain to the state bar. And
now the Commission on Judicial Conduct, that covers mainly state judges or covers federal judges as well?
It's a state panel to review federal judges. You complain to the federal judges on your circuit level, like I would complain to the Ninth Circuit Review Panel.
Right.
In the state review panel told me, don't say a word about this to the judge you're complaining about. When in fact, the federal government, the first thing they do is they give your complaint and all the materials to the judge that you're complaining about. I don't know the reason they're different, but for what it's worth.
Yeah, so we filed a judicial complaint against the judge we're suing, and the clerk in the Fifth Circuit said, well, we're going to wait till the outcome of the case before we investigate.
That's fine. Push the judge through a bunch of hoops so that the judge has a whole bunch of more opportunities to screw up. So you have a whole lot more to complain about.
Absolutely. Let's see. Can we go back and a little more detail talk about your Section 83? Because it appears that is what the main tax the tax movement's missing, right? That is, they largely get a lot of it right, but not this, and they leave it out.
Section 83 is probably one of the easiest things that they could catch up on. It's just one statute. Section 83A explains how property received in exchange for services is taxed. That's the first sentence from Montalep Systemed versus Commissioner, Fifth Circuit, 1992, 496. Let me see, 956 Federal Second, 496, 498. There. Now you know the exact page of the law library to go to find that sentence. 83 explains how to tax your paycheck, your self-employment earnings, your independent contractor fees, your tips, your salary. If it's property transferred because you rendered services, 83 governs. But the government says, oh, paycheck, 61A, gross income. And the government starts you in 61A. When Revenue Ruling 2007-19 from the IRS says Section 83 provides for the determination of what is gross income when an independent contractor or employee sells their services. It's not an automatic. Section 83 determines. You don't have a choice. And Pete Hendrickson will say, oh, I've got a choice. I can ignore this law. Why would you do that, Pete? Because I can't understand it. Same with David Champion. They can't interpret it. Go to Section 83A, the tutorial on my YouTube site, Take from Caesar. Go to wevgov.com to the federal income taxation page and scroll down to the last third of the page. It's about Section 83. And you'll see it's a solid argument. They can't deny it. They had their chance in wevgov.com/Orth. After having the argument for 26, 27 years, they can't even talk about it. And yet it governs whether or not they have the right to even speak to you when all you've done is sell your labor. It's that bad, that ridiculous.
Yeah.
So
I reviewed those videos that you're talking about and your the whatever you provided reading wise, and it's a very detailed for anyone that needs to go and and gather their thoughts on it, and that we didn't cover here, but it's definitely available.
As you collect your thoughts about it, the complexities of it will fade away. When you grab another complexity and you understand why I would, okay, now I get it. And it might take 2 or 3 times through the video, but when the complexities sink in, then you can brush the complexities aside as you read through the language of the statute and know you're headed through that statute to prove all property is a cost. When all property is a cost, labor is a cost. And if labor is a cost, compensation for labor is not profit or gross income. My objective is to prove I don't owe the tax. And when you look at the law and apply it as it's written, son of a gun, Section 83 says only the excess over the amount paid is gross income. What's the amount paid? Regulation under Section 83 say the amount paid is the value of any money or property that you paid for your paycheck. Any means all of it. The Supreme Court says so 5 or 6 times. 29 or 30 appellate cases say that's right. Any means everything. And in tax law, it says any money or property. Well, that would include my labor now, wouldn't it? The most sacred and inviolable property of man. And so I'm going to deduct the value of my labor from what the government wants to include in gross income. And suddenly I wind up with nothing to include in gross income.
Well, yeah. So
just a second.
Okay.
Then you got these morons out there to say voluntary compliance. Volunteer into what? The tax code doesn't impose a tax on the value of labor, so there's nothing to volunteer into. So when you know Section 83, the tax code falls apart. Social Security is an income tax. So Section 83 applies to all compensation. That means Chapter 21, FICA, wages. Chapter 2, self-employed earnings. Those are compensation for services. So Section 83 applies wherever it's an income tax and compensation for services. So Section 83 destroys the IRS and what they like to do to the working man. And that's why my manual about that is called Codebreaker, the Section 83 equation. It breaks down the entire code and compensation for services. I'm the only one that's written about it. I was done with my manual 30 years ago this month. and the government can't talk about it at the same time they say it explains how to tax you. Go to wevgov.com/Orth and read the exchange of briefs, and you're going to come away going, they're running from it. I got the goods on them with it. That's just one of my arguments out of my 1994 treatise called Codebreaker.
Yeah. So you answered the question I was going to ask about wages and property and how the government gained interest in your property and such not. But
it's wonderful to know all this stuff and to be able to repeat it upon just somebody's slight inquiry. You can tell I've been teaching this for 33 years. And
absolutely.
It hasn't changed shape. That 58-page memorandum, it's got a table of authorities about 7 or 8 pages long. All the court cases and statutes I cited. When I filed that January 1st of 2006 with 80 members of Congress, I could take that table of authorities and go case after case after case after case after case, clear through the list of cases alphabetically that I cite in the 58-pager and tell you, as I read the name of that case, why I cited it. To go right through over 100 cases and say, I cited this case because it says this. I cited that case because it says that. I cited this case because it says this. I mean, heavy into my work and my conclusions. And that's paid me the biggest dividend, is that I read slowly, but I spent the time. I did the work. And you'll see me come out head and shoulders above everybody else when you see how simple I've made the code, how I've conceded, okay, citizen of the United States, tax me if you can. I get into the law to show, what are you doing talking to me? And everybody else is going, I'm a non-resident alien. I'm not a resident of Washington, D.C. Yeah, calm down, citizen breath. You get done with my work, you're going to be glad you're a citizen of the United States.
And anyway, what would be your biggest argument against all this patriot mythology stuff? I mean, what can you speak on that briefly? Just my biggest
argument is not everybody's wrong, but the ones who aren't wrong are still frivolous compared to the very direct challenges I can make based on the fewest number of provisions or the most relevant provisions, right? Hitting it right on the head. The definition of citizen. Section 83A explains how to tax the workforce. You can hear how my axe is huge. I'm taking big swipes at the IRS, whereas somebody could take a small one and say, well, this definition way back here in the back of the tax code, not even applicable to the provisions they're looking at in the chapters the IRS wants to use. My specialty is the chapters that impose the tax, because the structure I discovered within them and the provisions in those chapters 1, 2, 21, and 23, take care of the whole show. And they do it with rock solid arguments. I'm not in the definition of citizen. And I got 20 Supreme Court cases about how to interpret statutory definitions. So they can't go anywhere against me.
And so when you made all these arguments, this was all in state or federal court. Was it ever in the IRS tax court?
It was on paper.
Okay.
And so it was always in U.S. tax court or federal appellate court, maybe a state tax court.
Okay. So the reason I'm asking is, in the IRS tax court isn't really an Article 3 court, right?
Never been into that. I'm a citizen of the U.S. Let's see what you can do to me.
Yeah.
So I start in the tax code. This is what I tell people. Think of all the lessons you've learned from other people, every one of them. When you have lost every one of them and you're required to argue the tax code, that's where I start. And I don't do any work before that. I don't do any work before the tax code.
So if the IRS brings an indictment, they're going to bring it in tax court, right?
No, tax court is civil. You owe us money.
Okay. So, okay.
U.S. District Court.
So they would bring an indictment in U.S. District Court if they wanted to bring one.
Maybe a criminal complaint first, and then change it into an indictment after they can get a grand jury together.
Okay. So the tax court would just be for civil fines and things of that nature. And,
yes.
And what argument would you make in that tax court to get out of it?
I would make the same arguments, knowing they'd penalize me for making them, or I would make those arguments and say, don't decide these, don't bother looking at them. I'm reserving them for appeal because I know you won't decide the law in this court. So just leave them alone. I'll get to hopefully a real judge later.
And what percentage of judges do you think follow the law these days?
None.
None.
Tax law is sensitive. It's about money. You can't have it. They get the money. Period.
And on other issues?
Other issues, it's still it's a guessing game. On big issues, you won't get the law. But let's look at if someone were to sue for false imprisonment, I would say never do it without an attorney, because I can find a bunch of cases where attorneys won settlements for people who are wrongfully imprisoned. But I can't find any cases where a pro se won. And so that's really the only advice I have for them is get an attorney. They know the lay of the land. They speak to other attorneys. They know the judges in the court that you would take it to locally. And so get their take on how good of a case do I have? And who knows, they might have had one in the past as shoehorn, basically the same type of case, just substitute a couple of the facts to stick you into it and file all the same paperwork and go get the settlement. Okay. It's nice when somebody comes to an attorney with a case that simply can't be refuted. We got the goods. They had no business arresting you. And while in custody, they broke this bone, that bone, and the other, whatever. When you've got the goods on them, use an attorney. Why waste your time on the corruption of a judge? Get an attorney. They're going to know enough so the people you're suing know they better settle out of court.
And
that's
how
really
do you
the key to happiness?
How do you find a good attorney that's going to prosecute your case properly?
Here's what I would do to find a good municipal tort attorney, meaning the sheriffs or the cops did me wrong, or they knew I was innocent and they falsely charged me. I would go to the probably to scholar.google. I would go to just a general search on the internet, and I would go to the U.S. District Courthouse. I'm looking for V period, and then the name of the city or county that I want to sue, and maybe a couple other counties. Like if I was in LA and I wanted to sue for false arrest, I would do a search for false arrest cases that took place in Costa Mesa, LA County, Orange County, Riverside County, and this court, Middle District of California, Northern District of California, Southern District, and see what kind of pop-ups I get on case law where the government got taken to court and had to settle out because the cop threw this person on the hood of the patrol car, or threw them into the back of the patrol car with cuffs on and they bumped their head on the door, or whatever. And I want to sue. I want a good attorney. You're going to find there's a guy in Sacramento. I don't know if he's still in practice, but he was known as the Bulldog. He'd take on the worst cases. Like, oh, this white deputy raped a black girl in the jail. He'd run to be the attorney that takes it, okay? And so you do your search of local cases for the last 5 years, and you'll probably find, especially at the courthouse, do a search for municipalities being sued, names of cities, names of counties being sued, okay? And then you take the ones out where it was a corporation that sued them. Only the ones where individuals sued them. And you study those tort cases, and among them, hey, this attorney's name came up on 5 of those lawsuits. And there's nobody else that had more than one in the database. I'm going to go see that attorney. Look them up in the Yellow Pages. Who has the biggest ad? Who spent the most on their website? And go to court and check out their records. See what cases they've handled in your district court. And you'll get a sense of who's the good one, who's the bad one. Call the Federal Public Defender's Office locally, as local as you can get it, and say, yeah, I just got a conviction overturned. Who would be a good attorney to go to? Who's a good mop-up attorney? And they're going to have 1 or 2 post-conviction attorneys at the top of their list, and they'll share it with you. So I would look at the record for cases the government lost with local attorneys on municipal tort, and see if there's an attorney that consistently rings the bell, that obviously doesn't mind at all suing a municipality.
Mm-hmm. And so, real quickly, if you have something happen to you, if you get a citation, you get arrested, whatever, what's the first thing you should be looking to do?
Motor vehicle code, traffic violation, civil or criminal. I've been cited when the cop knows I was engaged in public vehicular travel. Go to wevgov.com to the public vehicular travel page and look at all of those sites from across the country, state and municipal, that say public highway, any way, lane, street, road, boulevard, or other surface open as a matter of right to public vehicular travel. It's in the law from coast to coast. In 2005, I was looking at a brief that I wrote with Kurt Riggins' work in it, and I was curious. I said, why do traffic judges run from this brief? Why do they always dismiss the ticket? They never say why. And I read the brief through about 10 times, and each of those 10 times, one phrase stood out to me: open as a matter of right to public vehicular travel, from a 1961 Sessions law here in Washington State. I said, damn, if that doesn't sound artful. And I went to the internet and typed in open as a matter of right to public vehicular travel. I got 464,000 hits.
Wow.
I've gotten as many as 22 million hits on that phrase. It's in the law from coast to coast. So I don't argue that I have a right to travel. I argue that the motor vehicle code hasn't been written to apply to this activity, public vehicular travel. The roads are open as a matter of right to public vehicular travel. Operating a motor vehicle is a privilege. And so there are two things. And the original motor vehicle code for my state only addresses the motor vehicle code to commercial use of the streets. Please put it on the record, proof that the legislature has expressed an intent to broaden the scope of the motor vehicle code to include new subjects, and they cannot. So it's a statutory scope argument against the government instead of a constitutional argument in favor of my rights. It's
Okay.
in the mirror. It's the same argument. It's just argued with the other set of tools that are in the same drawer.
And
that's what I do for traffic. And as I said, I only helped innocent people. If they screw with me, I'll be innocent. And so if I'm innocent and they should know it, if I tell them I'm innocent when they arrest me and they don't do a follow-up investigation, they're kind of in violation of Gasho versus US. An arresting officer would have to have reasonable suspicion. So you get them on the stand, where's your reasonable suspicion? And when you're arrested, when you're cited criminally, whatever, the first thing you do, you write down all the facts, and you're going to stand on those facts for the remainder of the proceeding, right down to the way the cop's breath smelled, and you get it notarized, several copies of it. Then you file a State Disclosure Act request, a Public Disclosure Act request for documents to the county, the city, whoever's messing with you. Please supply me a copy of any and all documents the municipality uses to educate any and all officers, prosecutors, and agents of the county on the essential element of mens rea, or criminal intent, as discussed in U.S. versus Alonis, Rahafe versus U.S., and in Morissette versus U.S. You cite those three cases, and in Gasho. And you ask them for a copy of everything they use to educate their staff on criminal intent, because you know they don't. And it's an essential element of every offense. So there's one thing that can make you innocent they never even train on. And failure to train is one category of recognized tort remedies. Failure to train, we're going to punish you X number of dollars for failure to properly train your staff. So the first thing you ask for is something they can't give you. Ha ha ha. Because you know they don't train on it. You told them you were innocent and they still arrested you. That means they don't train on it. And then you get them on the stand and humiliate the hell out of them.
mm-hmm.
Is criminal intent an essential element of every offense? And they're going to say, no. Well, gotcha. You're fired.
And you would do that even in a municipal court?
Oh, yeah. Criminal intent, period.
Okay.
Criminal intent, criminal charge. Every single criminal charge. So I got a lot of protections as citizen of the U.S. The law applies to me. I'm not a sovereign citizen. No, sirree. Let's get into the law. I did this the hard way, Your Honor. This is law. If you can't take it, get that robe off. I'm tempted to arrest you.
And some of these municipal court judges will say, "Don't bring that Constitution crap into my courtroom." What do you do then?
Your Honor, what, Your Honor? That wasn't said loud enough. I need that for the record. And you stop them right there. They know you got them.
Yeah.
You stop when the court runs at their speed. Your rights run out the door. At every single juncture, I stop and look at my rights through the checklist I know I got in my head of what my rights are. Like I knew when that judge in San Mateo County didn't let the tattoo parlor owner allocute to say, I wasn't in contempt. You told me to see two different doctors. And when she deprived me of that, that was a constitutional right. When you know a whole bunch of these, you know that if they mismanage discovery, you can get your case dismissed. You know, if they mishandle that or if they disclose certain things, I can get my case dismissed.
Mm-hmm.
And so you read cases that get dismissed, and it's the key to freedom.
And if they railroad you or you eventually get your tickets dismissed or whatnot, are you going to sue them in the federal court, or are you?
You choose your battles.
Okay.
If it's a state that screwed you, you can't go to federal court. Right. They have sovereign immunity. But if it's a municipality, city or county, you don't even have to tell them in advance. Sue them in federal court. I like telling them in advance. It gives them an opportunity to settle out. Because once you sue, you got to pay an attorney to debate all the motions to dismiss that come in and handle trial procedure and stuff. And I'd really rather settle out.
Yeah. And so what's a reasonable settlement for a false arrest by a municipality? What should you be looking for if they didn't beat you up? If they didn't beat you up and all this stuff,
folks, get ready to write, folks. I'm going to this Word document for the Ramirez decision. It was, they're going to say, okay, you were in jail for 30 days and we award you $21,000. And so you extend it out for the whole year and you say, that means per year, it would have worked out to be X number $1 million per year. And I did that with certain settlements that I saw in a certain case, prorated like that. And I figured them out for how much that would be for a year if I got the same rate this guy got for 30 days of false imprisonment. 12 times that is how much I'd get for a year. And I have, write this down, folks. You come up with it right on the web, no problem. Pitt, P-I-T-T, Pitt versus District of Columbia. Pitt versus District of Columbia, 404 Federal Supplement Second, 404 Federal Supplement Second, 351. 404 Federal Supplement Second, 351, DC Circuit, Washington, D.C., December 23rd of 05. $100,000 for malicious prosecution and intentional infliction of distress from 6 days imprisonment. $100,000 for 6 days. That works out to $6.3 million per year. That's the parameter I would use. It's at the low end. You could find one that's way up there at the top, and that's Ramirez versus Los Angeles County Sheriff's Office, $21.6 million per year, because they got $18 million in damages for 10 months incarceration. It works out to 21.6. So I went to a low decision because I want to realistically apply for relief out of court. And so I would choose rather Ramirez, or Pitt versus DC, at only $6.3 million per year. Hey, I was in prison for 3 years. That makes about $20 million false imprisonment.
I think California has since implemented some limits on that, right? Via statute or no?
I don't know. I'm not heavy into California. I know that California, from the case law I have read, it seems that they require that you not only were falsely imprisoned, but that you were injured as well. Because every case I looked at said, and for injury. And a couple of attorneys I know that were reviewed by the client, they said, how are you injured? I always wanted to hear how you were injured. So maybe California has added a level to it.
How about loss of liberty?
That's the one. It's an unreasonable seizure, is how you have the unlawful arrest, and there's a standard fee for that. I think in Washington it's $50,000, and then you have an unlawful or unreasonable seizure that applies to the jail time.
Okay. Well, we're just over 2 hours. I want to be respectful of your time. If you need to go, great. If you have some more we want to talk about, I'll be happy to
Let's
be
see.
happy to
I
stay.
like showcasing that flash drive. The work I've done against the IRS is in Microsoft Word on that flash drive. My treatise for U.S. District Court and Federal Appellate Court, already in Microsoft Word, written with the quality you see on the tattoo parlor owner page. So I write with an elevated expertise and skill. And you have the course on how to write and file citizens' criminal complaints. Course number 4, drive-by litigation, which is a real pointed set of tactics for using criminal complaints. And then you have this one, takefromcaesar.com. It was a website. I still own it, but I'm not going to put this course on the web. When the healthcare bill was enacted into law, March of 2010, I wrote a course about it. It took me 4.5 hours to analyze the healthcare bill, 2,500 pages in PDF, because all I did was this. I downloaded the 2,500 page PDF document, copy, and then pasted it all into a Microsoft Word document. And then, you know how in Word you push Control H and a window comes up, says, what do you want to replace? What do you want to search for? And what do you want to replace it with? I said, I want you to search for security. And I want you to replace it with bold and italics, security in 14 pick, and pushed replace. So everywhere it mentions Social Security in those 2,500 pages, it was in bold and italics and a bigger print. And gross income, replace it with bold and italics and 14 pick. So everywhere it mentions gross income, I know I got an argument for that, don't I? And so all my argument keywords were in bold and italics and bigger print. And I went back through the 2,500 pages and discovered that 1/6 of it is an amendment to Chapter 1 of the Internal Revenue Code. Chapter 1? Isn't that the chapter where I'm only named in regulation? Well, I can ignore those, can't I? Cool. 1/6 of the healthcare bill. Went through it again. 1/2 of the healthcare bill is an amendment to the Social Security Act. I asked it to make security bold and italics and larger. And almost half of them are an amendment to the Social Security Act. So I got this idea in my head, screw the healthcare bill. And what you have is the Social Security Act of 1935 that had that very restrictive definition of citizen in it. And then in 1939, they published the first tax code. And in section 3811, collection of taxes in Puerto Rico and the Virgin Islands. A, Puerto Rico, B, Virgin Islands. And then in 1954, they rewrote the tax code, made it 10 times as voluminous and 20 times more complex. But I found in the back of our tax code, section 7651, parentheses 5, parentheses capital A. One of those above it has been repealed, so now it's 4A. 7651 4A says any reference in section 28A of the Revised Organic Act of the Virgin Islands to, quote, any tax specified by section 3811 of the Internal Revenue Code, end quote, shall be deemed to refer to chapters 2 and 21. I was on a search through the tax code for references to chapters 2 and 21, Social Security. And here's a reference that says when you're in the Virgin Islands and you read the Revised Organic Act of the Virgin Islands and it says section 3811 of the Internal Revenue Code, it really means chapters 2 and 21. Section 3811, I didn't know what that was. So I went to section 3811. It doesn't exist.
I said, well, the possessions have been around a lot longer than the 1954 tax code. So I went to the 1939 tax code, section 3811, collection of taxes in Puerto Rico and the Virgin Islands. In 1954, when they rewrote the code, they just split that statute up into chapters 2 and 21. So I got to the bottom of the healthcare bill in no time, and I made an entire course about my analysis of it, because they say if you make gross income less than 400,000 a year, you won't pay extra taxes. How does Section 83 operate? In your conclusion, I made any gross income whatsoever. So there goes another tax they imposed with the healthcare bill. You can't buy insurance outside of your state, pal. This is the healthcare bill. You got to buy health insurance from the exchange within your state. Well, to POTUS.com, POTUS, P-O-T-U-S, President of the United States, to POTUS.com, another one of my websites, is a message to the president. Read that homepage. It'll say, I got a constitutional right to buy insurance all over this country. 1897, Algar versus Louisiana. Algar was a resident of Louisiana that had a law saying you can't buy insurance outside your state. He took it all the way to the Supreme Court in 1897. The Supreme Court says, oh no, commerce is for the entire United States. He can buy insurance anywhere he wants. So there's another tenet of the healthcare bill that's destroyed just because I did the right amount of study of the right things when I first got into law. 1897, insurance out of state. I read a case like that. And this is in 2010 when the healthcare bill was enacted. I read a case like that. It was 1990 when I read that case. And I recalled it. I looked it up. There it is right there. So another piece of the healthcare bill. So that entire course with audio tutorials is on the flash drive. And it's a magnificent flash drive worth 20 times the price. The writings are impeccable. The knowledge of the law is mind-boggling if all you know is the movement. I've proven time and time again that they don't debate me for a reason. I've wanted to debate since 1993, and no one will take me up on it because first things first, do you know anything about the statute that explains how to tax the workforce? And they have to say no, Section 83. Well, what the hell is there to debate? They're kindergartners when it comes to real knowledge of the law. And I'm happy to say that. I hope they hear this. And you tell them Dave Myrland said hi right after he got done laughing about you. So I'm serious about all this. Serious as a heart attack, and nobody runs through the law like I do. And I got a lot of I got a lot of help from pushing my mind through law the way a prosecutor has to learn what triggers a criminal complaint, what triggers 5 years in prison, what triggers 10. I want to know the parameters. So if I spot it, if somebody pulls that on me, I can stop them right there saying, you know, I'm a nice guy, so I'm not going to arrest you. But here's what you just did right in front of me. And I got to tell you, you know, there are people that will arrest you. So you got lucky today. You're welcome. Now, you didn't want to hit me, did you? Or you didn't want to say that to me, did you? Or whatever, and back up and be nice guys and calm the conversation down. But other than that, I got it ready right here. Citizen's arrest. Boom, gotcha.
So we need to look up the citizen's arrests in all of our states. That's what we need to do. Or the statute.
Yeah, and you already got all those appellate cases on the citizen's arrest page of wevgov.com. You're going to have a brief of citizen's arrest in Word in the flash drive, and go to my YouTube channel and take the video table of contents. It's an hour, 7 minutes long. The video table of contents of the flash drive. And you'll see it's wonderful. I got a bad attitude and I write very well, on par with the best attorneys. So you'll mean a lot more to whoever reads your documents than had you not purchased my flash drive and taken it to heart.
And have you bought any insurance out of your state?
Any insurance?
Yeah. Have you been able to purchase insurance out of state? Have you tried that?
I don't purchase insurance.
Fair enough.
My automobile is a tribal government vehicle with an exempt license plate and insurance through the tribe's bond.
Gotcha.
Ha ha ha. Ha ha ha.
All right.
And I'm a tribal attorney and a tribal member.
I like it. I like it. All right. Well,
But-
I think that's a good place to wrap it up. I think we're going to have you get back on if you will indulge us. But
on the flash drive, there's a course about COVID in the schools, or COVID
Okay.
enforcement and cleaning up the schools for all this sex education and the rest of it we all heard about. I don't want to jump in the toilet to describe it slowly. It's unforgivable what they feel they have the right to do to everybody's children. And I got a really harsh attitude about it. And I wrote a course about stuff I would do in return for what they've done to the children. I don't have kids, so it wasn't my affair. But I finally took time off and thought about it for a few weeks and came up with a course that's got some real knobs on it. And I mean, do things that'll get the teacher decertified so they have to go to another state to get a job. I'm not going to play nice. It doesn't happen. Not in my world.
Yeah, I haven't gotten to that section of the thumb drive, but since you pointed that out to me, I'm definitely going to have to review that, since a lot of our cases are about that, and that seems to be the main thrust. But I think there's some...
Sure, and get a group together and charge a tuition, and let's have a Zoom seminar like this, and everybody pay $50, and I'll send them out a flash drive, and they get to attend a seminar in person, hands-on, ask questions that aren't answered on the course, and I'd love to do seminars.
And you'll do a seminar on any topic?
Yeah, you'll see there's quite a few topics on that flash drive I can get deep into.
Okay. Yeah, I think probably the travel would probably be the most of the most interest at the moment with everyone. But obviously, I would be interested in the COVID stuff, and a few other people as well.
You'd probably be very interested in that $25,000 check on take from Caesar.us too, wouldn't you?
We've talked about that. Yes, sir.
Yeah,
yes, sir. Yes, sir.
I snagged the city in a violation of law that I created. I knew they'd violate the State Disclosure Act, and so I submitted records a certain way to where the prosecutor ignored them. 4.5 years later, I sued, and I got $8.23 per day for 3,011 days worth of violations. $25,055. Next case, please.
Man, you are very impressive with your recall and how much I guess that comes with 30 years of experience, I guess, but you must have a special mind for this.
And $1.5 million worth of drinks made at high speed. I knew every joke on the planet, every drink, every customer. Target rich, very memory intensive occupation.
Right, right. And for those of you who don't know, Dave was a bartender, right?
Yes, to probably the middle of 1990, 10 years worth.
And you were working that job when the IRS pissed you off, and we're off on this tangent.
Yes, the IRS came to my doorstep. I was living in Federal Way, Washington. No pun intended. And IRS field agent Marty Webb, a woman about 6 feet tall, slender, short brown hair, read me the act on my doorstep. You didn't claim your tips in 1984. I said, yeah, I figured you'd find me one day. We'll sit down. I'll pay this. I got a lot going for me. And so I got an appointment set up there on my porch, and she left. And 3 weeks out, 3 days before the appointment, I called. I said, I can't make it. We need to reschedule. And 3 days before the next one, I called and said, I can't make it. Let's schedule. 3 weeks out. Before that one, I got another job, moved away, and started studying law. So she couldn't find me. And so in June of '88, I started studying federal tax law. And in 5.5 years later, January of '94, I wrote my treatise, my conclusions about how the IRS is misenforced by the tax court and by the IRS, and named it Codebreaker. And those are the findings I'm still teaching.
Well, the law hasn't changed on that much, has it?
No, but not only that, I did a thorough enough job that my treatise just doesn't change. I knew what I was doing when I studied the law. It's still the same. The government is still silent. And it was that long ago, 30 years ago. So I'm one of the only living tax protesters, and I'm the one that actually retired a year ago. Everybody else is still in the game. They're in it till they die. Bill Benson, you know, what's his name? Dick Simkinen, um, David Champion. He'll be in law till he dies. Pete Hendrickson. I'm the one that retired. Now I'm just selling my teachings. I'm not writing pleadings for anybody. And in the criminal intent portion of that flash drive, criminal intent course, segment number 3, unzip it. And there's a letter in there that I wrote that bring my 2 key findings. I'm only named in a regulation, and you deprive me of Section 83 to tax my pay. Those 2 findings are thrust at the IRS in this letter or at the DOJ saying, I got the letter that says you're convening a criminal investigation against me, or a grand jury says this and that about the law. And if you think you're going to a grand jury, don't lie to them and tell them I'm willful, because I don't believe I have a duty. And if you're going to have a grand jury, make sure you subpoena me to testify before the grand jury, because I'm not guilty. So everything's right in one letter with a couple of exhibits that you can introduce yourself with to the IRS in a way that hopefully puts out their fire that says you're going to prison. That's what I'm about, is keep your bacon out of the fire. They're always going to get your property, liens and levies, so I don't do those. Criminal investigation, criminal indictment, I got a lot to say, and a lot of it already written, and it's on that flash drive.
Gotcha. And last question, would you briefly talk about the 16th Amendment and what it did or didn't change?
The 16th Amendment case law goes like this after a few cases. And some cite Smiatanka, and others cite Pollock Farmers Loan case. And you'll find one branch of it says that the 16th Amendment didn't change anything about taxation authority except relieve the requirement for apportionment. And another one will say this is the sole source of income taxation authority, that it did not exist before the amendment. And it was never one of the fields that I chose to get into, because I was so excited about statutory challenges I could make that I stuck just with my findings and my own analysis.
All right. And well, I said last question, but one other topic I want you to touch on, and we don't have to go too far in depth, but property taxes.
I've only done one case with property taxes, but a guy in Florida picked up what I did and has really chopped some arms off in Florida with racketeering lawsuits, not criminal complaints. You get the briefing that I did for Washington in the flash drive, and it is a U.S. versus Patzer challenge to Washington State property taxes in RCW Title 84. That's Revised Code of Washington, where you have a definition of person. The term person includes firm, estate, corporation, foundation, or association. And it doesn't mention trust or individual. But over here in the definition of person and several other places in Washington state law, the term person means, or the term person includes, firm, trust, estate, corporation, individual, whatever. And it does mention trust, and it does mention individual in other definitions of person in Washington state law. Patzer was driving from Washington to Oregon, probably in the year 2000, from Washington to Oregon, to Idaho, I mean. And he got into Idaho, and I think he stopped at a diner or something. And a policeman, or an Idaho State Patrolman that noticed him, says, that guy's been smoking pot, and waited for him to drive away from the restaurant or gas station, whatever, and pulled him over. Suspicion of smoking marijuana in violation of our state DUI law, driving under the influence, busted. And since when we searched your car, we found illegal weapons and illegal drugs, and you had just come from Washington into Idaho. We're handing this off to the federal government. So the Fed charged him for illegal guns and drugs under the tax code. They got illegal guns in the tax code. I don't know why. And he made this argument in district court. His attorney made the argument, denied, you're going to prison. And he made the argument again on appeal, where, hey, Your Honor, my client was pulled over for abuse of marijuana, specifically in the police reports. But we have these laws over here in Idaho statutes where they do mention marijuana, that this narcotic, that narcotic, comma, marijuana, comma. But over here in the Dewey statute, it says this, that, and narcotics, comma, and shall not operate. And it doesn't mention marijuana. That's indicative of legislative intent that marijuana be a substance, the abuse of which shall not trigger the DUI statute, or they would have put it in there like they did in these other laws. And district court says, oh no, he's going to prison. And the Ninth Circuit said, that's right. That's indicative of legislative intent that they didn't include marijuana in the violation. So you had all these news reports come out. It's legal to smoke pot and drive in Idaho around 2003, U.S. versus Patzer, Ninth Circuit Court. So a trust in Washington that owned land and an individual that owned land, both of whom were under harassment from the county assessor for property taxes. I wrote them a civil rights lawsuit for U.S. District Court against the county assessor. And the trust and the individual sued the county assessor under a Patzer argument saying, yeah, we're mentioned over here, individuals and trusts in these other definitions of person, but not in property taxes. What's up with that? And they got nowhere. The case was denied. And they declined to go to the Supreme Court because of the odds of losing. The government never gives up tax money. And I just proved with this one, trusts and individuals don't owe property taxes. So right around 2014, 2015, maybe, I was giving a lecture to a small group here in Seattle. And a guy approached me and says, hey, I used to go to your seminars on the North Shore of Lake Washington a few years ago. Remember me? I said, yeah, how's it going? He says, good. Hey, I used your property tax argument when they came after me, and I went to a mediation hearing against the county assessor's office, and they had the county prosecutor there to argue. And she's over there going, everybody owes property tax, Your Honor. He doesn't know what he's talking about. And I'm over here with your brief, and I hold it up in the air. I go, this brief, Dalbra Trust, you couldn't deny a word of this. And she looks over at him and she goes, where did you get that? He goes, your office. She goes, that file's supposed to be sealed. Why would you seal a case that you won? That's the one you're supposed to keep at the top of your holster. And when anybody mentions the argument, you're supposed to drag that out and beat the citizen over the head and neck with it, right?
Right.
They sealed it. And it's just a state statute. It explains how to tax property if you're going to tax it. And it was sealed. Where did you get that? Your office. That's supposed to be sealed. So, and that's the only thing I've had to do with property tax. Now, Steve in Florida, he took up that argument, and he's been going for it with RICO suits on property tax controversies. And I guess he's just mopping the floor with them down there because he found a very similar type of argument to make with them.
Yeah, no,
Anyway.
he's been very successful. He's very
that's
tough.
right. You know, Steve.
He's very tough like you are. I haven't met him, but he has agreed to come on and do a show with us. So we're looking forward to that, and we'll drill down on some property taxes with him. But we have a few
let me tell your audience.
Yep.
Let me tell your audience that you're right to view Steve as every bit as interesting as I am. He's carved out a trail for himself in the field of protest and law litigation. And you don't find a whole lot of them out there.
That's a ringing endorsement from you, I believe.
Yes.
Well, I want to thank you for spending the time with us. We're gonna get some feedback from this and see who's interested in what seminars or what we can put together on that front. But
Yeah.
we are very gracious for your time, and you provided a lot of dense things to go through, and we have a lot to study for sure. But I'm gonna give you the
Get the
last
flash
word.
drive, folks.
I'm gonna give you
Yeah,
the
get
last
the
word.
flash drive, folks. And since the last time I spoke with you, I came up with a way to kill the coronavirus. You tell Hillary it intends to testify against her.
Yeah, that would do it. That would do
bitch.
it. That would do it.
Okay, it's my pleasure. Have me on again. Okay, this is fun.
Absolutely. Thank you.